Thank you. Good morning and welcome to the Law and Crime Network. I'm Linda Kenny Bodden, and I thank you for being with us as we kick off our coverage. We're following the arraignment of the suspect in the 1996 shooting death of rapper Tupac Shakur. Dwayne Keefe D. Davis will be arraigned in a Nevada court today. He was one of four suspects identified early on in this investigation and was described by authorities as the ringleader. Though he is not accused of being the actual gunman, Davis has admitted that he provided the weapon used in the drive-by shooting in prior interviews. He was arrested hours before prosecutors announced that a Nevada grand jury had indicted him on one count of murder with a deadly weapon. They also voted to add a sentencing enhancement to the murder charge for gang activity that could add up to 20 additional years. That is if he is convicted. Now, I'd like to bring in my guest, Richard Schoenstein, who is an incredible trial attorney, to talk about this case. Actually, you know what? Actually, even more important, our own Anjanette Levy has a look about, and a report for you, our viewers, about this. Let's go.
I'm Anjanette Levy, coming to you from the Las Vegas Strip at the spot where police found rapper Tupac Shakur shot on September 7th, 1996. Later this morning, the man accused of ordering the hit on Tupac, Dwayne Keefe D. Davis, will enter a plea to a murder charge in court. Tupac Shakur's family and friends have waited more than 27 years for this day. Las Vegas Metro Police took Davis, a South Compton Crips gang leader, into custody last Friday after a months-long grand jury investigation. Police say Davis ordered the murder of Tupac in September 1996 after Tupac and Death Row Records CEO Suge Knight jumped Davis's nephew, Orlando Anderson, at the MGM Grand over an old beef.
Dwayne Davis began to devise a plan to obtain a firearm and retaliate against Suge Knight and Mr. Shakur for what occurred inside the hotel against Mr. Anderson.
Davis confessed in a statement years ago to giving Orlando Anderson the gun to shoot Tupac, but that statement could not be used against him in court because of an agreement with police. Orlando Anderson died in a shooting in 1998, so he cannot be prosecuted. But Davis wrote about providing the gun to kill Tupac in his self-published book, Compton Street Legend. He's also granted interviews to YouTube channels in which he spoke about the shooting of Tupac Shakur. Right now, Dwayne Davis is being held without bail. The judge could set a trial date for him after he enters a plea later today. Stay with Law and Crime for continuing coverage of the arrest of Dwayne Keefe D. Davis. In Las Vegas, I'm Anjanette Levy.
And again, as I mentioned too, I have a great trial attorney with me, Richard Schoenstein. Richard, at a hearing to enter a plea, do you expect Keefe Davis to say not guilty? I'm not going to enter a plea, or on the off chance, guilty, you got me?
Well, I think that last one is a very slim chance. I would expect him to enter a not guilty plea. I don't know why he would do anything else.
Yeah, so the hearing really isn't that important. It's just a matter of pro forma for him to enter the plea and set an attorney, see if he has one, I would imagine. But let me ask you something more importantly. This case, 1996, supposedly there's statements made, supposedly there's a proffer. Tell our, which is some kind of admission, tell our viewers what a proffer is and whether or not a proffer would be admissible as an admission or a confession in a trial such as this in 2023.
All right, well, the proffer, generally speaking, a proffer is something that a witness will tell the authorities when they're, investigating a crime. And I guess it came up in the context of some other crime that was being investigated.
Drug investigation, right.
And so the police will ordinarily make a deal that the information you give us, we won't use it against you for a different purpose. So if he made a proffer about having knowledge about the murder of Tupac, it wasn't related to the crime they were investigating, and that proffer couldn't be used against him.
Okay.
That statement to those police officers. But if he later gave the same information to somebody else, then he would be subject to having that used. If he
Well, let me just interrupt you for a second, because there's a piece of information you don't know and our viewers don't know. The hearing that was supposed to occur today, to enter a plea, has been continued to October 19th. Now, Richard, that usually happens because there's no attorney assigned. He wants to get a private counsel, or there's some other, not I won't say glitch, but there's some other reason, technical reason.
Yeah, well, that explains why it was so short.
It was shorter than my introduction.
Yeah, court hearings get adjourned all the time.
Right.
I have a line of clients who are frustrated by adjourned court hearings or other dates that we set. So that could happen for any number of reasons, including the defendant didn't have counsel or wasn't ready, or counsel wasn't ready, or somebody didn't have enough. So it's put off a couple of weeks.
Yeah, and he's without bail, so he's not going to get bail, right?
I wouldn't think so. Not
Not an attempted murder case. Not in a murder case. But let's go to what you talked about. Supposedly this proffer then that was given, okay, to the police and the drug dealer says, yeah, I have some information. Turned out to be information that about Tupac Shakur. They were investigating Biggie Smalls, also an unsolved homicide, though many people think they know who did it. When you have the proffer, there was a belief, according to authorities, that they said in a presser that they believed that Keefe thought he had immunity, that he couldn't be prosecuted anything related to Tupac Shakur. Then he gave statements in a book, supposedly. Why would those statements be admissible if they're not under oath and we don't actually know who actually wrote them and whether or not they were the actual statements that Keefe made?
All right, let's break that down a little bit. So
that's a lot.
The first question is, does the proffer immunize him in statements he later makes in a book? And the answer to that is probably no, because you make a proffer to police for the purposes of this case, and that is protected. But if you go give the same information to somebody else in some other context, it can be used against you. So now let's move to statements in a book. Can statements in a book be used against him? Probably. It's not going to be hearsay. It's going to fall within multiple exceptions to the hearsay rule. It's an admission against interest.
Which makes it reliable for the purposes of hearsay.
That's right. That is the feeling about. That's why we keep out hearsay, because it's not me reporting what you said is not necessarily reliable unless it's something you said against your own interest. Then it's more reliable.
Well, let's go to the third thing, though. When I was reading this and prepping for this morning, and knowing that you were going to be on and could answer all of my questions,
right?
I
don't know about that.
Okay.
We'll try.
All right. So let's assume the statement is, I gave a gun to my nephew in the backseat of the car, but my nephew was the one who actually shot Tupac, okay? And everybody in that car is dead. The other three people are dead, all but Keefe. But what was his intent in giving the gun? If he just says, I gave a gun, or does he have to say, I gave a gun because I wanted my nephew, I ordered him to shoot? And if no one's there to say he ordered him to shoot, how does the state prove intent?
Yeah, well, the state still has to build a case. So I assume they're going to show motive by virtue of the prior dispute between this group and Tupac's group.
Would you explain what that was?
I don't know. See, you're getting more in the weeds than I am.
Okay.
My understanding of this and my recollection from almost 30 years ago is that they had some sort of altercation.
Right.
They weren't necessarily on friendly terms to begin with. There's some sort of altercation. So the theory is that Davis essentially ordered that Tupac would be killed. And they got in a car. The allegation in the indictment is that he procured the gun. And they were in the car and they drove up and he handed it to some guy in the back seat who then shot, one car to the other. So if the statement is just, I handed him the gun, that doesn't prove the rest of the case.
Right.
It doesn't prove the intent. It doesn't prove he knew the guy was going to use a gun to commit a murder. Maybe he's going to say or imply, not going to say, because don't suspect he'll testify, but we'll see. That's down the road a while. Maybe he'll imply that they just had a gun for protection, as
That's what I was asking you about. Yeah. So also, I guess the prosecution says these were two separate gangs, factions. But how do you prove that that's a motive for an enhancement, even if it's true? And there's some question about whether it's true.
Well, remember, not only are they going to try to prove there's gang activity as part of the motive theory, but they have a gang activity enhancement alleged on the murder itself, which I think elevates the degree of the murder charge. So gang activity is very much going to be part of this prosecution as far as I can tell. And that,
you guys, this is just crazy.
Makes it a lot more to prove, right? Now they don't just have to prove that there's a guy in a car with a gun who hands the gun to another guy who kills somebody.
Right.
They have to prove this whole web of gang activity, which is and it's almost 30 years old.
Right.
It's not like gang activity from last week. You know, it's 1996. The iPhone hadn't been invented.
Right. How about we forget about that? And I also want to talk to you a little bit later on about Suge Knight. But in the meantime, I'd like you to listen with our viewers to a press conference, not the one this morning. You know, actually, there's a live presser right now. Let's go.
So that's what occurred today in court. Nothing will occur in the next couple of weeks until the next court appearance when his lawyer appears. Mr. Davis is being held on no bail. That no bail status will continue at least until his next court appearance. We will continue to ask for a no bail setting because we believe under Nevada law and the evidence in this case that the proof is evident and the presumption is great that he will be convicted of first-degree murder, and that allows us to ask for a no bail setting. I'll take some questions now.
Steve, what does it mean after so many months of work from your office to see him in court today?
Well, he's no different than any other defendant. I mean, we had a feeling this day was coming in the recent history based upon some of the events that have occurred in the last few years and few months. I like to see the person in person because on these cases, it's usually me that makes the ultimate decision on how to proceed. So I like to look at a person who's being charged with a crime in such a high-profile case. I like to look at their mannerisms. I like to look at their demeanor. I like to listen to them and kind of get a feel for their attitude.
Steve, can you say if he's been cooperating with investigators, if he's talked at all?
I understand that the day of his arrest, they were speaking with him, but I don't have anything further to say other than that.
Is there any coordination with LA about Victoria's VIG case?
I'm not going to comment on anything involving that other matter.
Steve Preston, CBS News. This is such a high-profile case, 27 years in the making. Can you talk about how that could impact the legal process moving forward?
Well, it's a cold case. It's been lingering for 27 years, but I felt there was sufficient legally admissible evidence to move forward. That's why we presented it to a grand jury. The grand jury agreed that there was probable cause to return an indictment, but this case is like no other case. In a court of law, we have to present sufficient legal evidence to hopefully prove his guilt beyond a reasonable doubt. Any case that's 27 years old sometimes presents some challenges, but we feel very confident that the criminal justice system will work in this case.
Mr. Wilson, is there any reason people have wondered why did it take so long?
Affiliation? Who's safety?
Davis' safety while in custody?
I don't know. I don't know anything about his safety and his contacts or his relationships with people from 27 years ago. I don't have any information regarding that.
Steve, I spoke to Tupac Shakur's brother yesterday. He says he feels that this case wouldn't have gone without a breakthrough for 27 years if Tupac had been a white man. Would this have been solved more quickly if Tupac had been white?
We don't look at the color of a person's skin. We have a number of cold cases that excellent detectives work on every single day. And whether the person is white, black, red, blue, or green, we move based upon evidence and what we can present in a court of law.
Steve, a lot of people have said, why did this take so long, especially in the last few years? Mr. Davis was very vocal about his involvement. Is there a simple answer to that question?
The simple answer is that this is an important case. We wanted to make sure we get it right. We wanted to make sure we had legally admissible evidence. We wanted to make sure that we felt comfortable that we had sufficient legal evidence. You know, if you're going to charge a person with
Okay. Mr. Duplessis, anything you want to add?
Ma'am, I was just on the strip. I know I was in violation of being out of the corridor, but I was checking the status of my applications because I know part of my probation I have to have some type of job or be in school or something.
Yeah, but you can't be on the strip.
Yes, ma'am.
All right, anything else? Anything else you want to add?
If I could just get another chance to try to check in school and be productive and show you that I can do better and follow my rules and my. Yes.
All right, well, Mr. Duplessis, here's the deal. I don't tolerate new cases. I don't tolerate it from anybody. If you pick up a new case and you get bound over on a new case, you get revoked in Department 10. That's my rule. Today your probation is revoked. I'm going to modify your sentence to 12 to 30 months.
Thank you.
So are you prepared to go forward with the arraignment?
We are, Judge.
No, Your Honor. In light of that, Mr. Meningo, are you prepared to go forward with the arraignment?
We are, Judge.
All right. Mr. Hamill, sir, what is your full name? How old are you? How far did you go in school? Okay. Do you read, write, and understand the English language? Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time? Do you understand the proceedings that are happening here today? Sir, are you familiar? There's only one count in this case, right?
Yes. That's correct.
Okay. Are you familiar with the one charge? Sir? All right.
Page 16, Montez. I think we're waiting for the special public defender.
Okay. Mr. Helmick, are you case report? Set it down for sentencing on?
It'll be December 4th at 8:30.
And Ms. Matthews, I need you to go back to parole and probation and do an interview with them in the next 48 hours. You understand?
Yes, ma'am.
Okay. Mr. Helmick, could you assist him with getting that done?
Yes, thank you.
Thank you. Mr. Beckett, you ready?
No, Judge, my client's on his way. Apparently, he went to the wrong court. I thought it was clearly explained, but he was on his way.
Okay.
Thank you.
Mr. Sexton, are we gonna go on some of these arraignments?
The one that I saw is not here yet. Here, Alan.
We're waiting for Howard Tuesday. Do you have Hollins on page 4?
I believe Beckett has them.
Oh,
Right there.
okay. We're waiting for Mr. Yanis, Mr. Wooldridge. Rose on page 11. Let's do Fernandez on page 14. C 345594, State of Nevada versus Cesar Fernandez. May the record reflect that Mr. Fernandez is present in custody. Mr. Sachs is here on his behalf. Mr. Thoman is here on behalf of the state. Is there a probation officer here on this?
Yes, Your Honor, Specialist Kennedy with PMP.
All right, I hadn't seen the violation report because when I prepped this calendar yesterday, it hadn't been filed yesterday afternoon. Mr. Sachs, have you seen it? Okay. What are we doing?
Approaching.
Yes, because I haven't read it. I'm not even gonna tell you.
Can you hear me? Can you hear me? I can. Can you hear me? Okay. Can you hear me? I can. Can you hear me? Okay.
If you have not been charged with the DUI, I'm going to reinstate you to probation at this time. The parole and probation reserves the right. They can rearrest you for a violation if you get charged with that DUI. Do you understand? All right, thank you.
Thank you, Your Honor.
Thank you.
Well, I guess I can mute that and see. Well, I guess I can mute that and see. Well, I guess I can mute that and see. Let me look something up. Hold on. Yeah, I know. I'm going to head out and wait for him to come back on. Who knows when he's going to appear? Oh, good. Good. Thanks, Camry. I'm just waiting. I tried to find the live court feeds like the courthouse, but there was no, it's on a break. They have a just like this. So USA Today puts up their pretty thing. I wonder if I can put up. No, really. I don't know. I'm not very exciting. I guess I could read the article. Let's go to Twitter. Haha, it's over. Let me tell you what happened. I'll share it. Let me share this Twitter thing. Let's do this. Stop sharing. And we're gonna present. Share screen. Okay. Nope. This one. Okay, right here. Tupac's murder suspect Keefe D arraigned in court. Well, that was anticlimactic. Keefe D showed up, but the lawyer he hired couldn't make it to the hearing. The matter has been continued for another 2 weeks. Tupac's murder suspect Keefe D is showing his face. You know, because I don't think Keefe shot him. I think his nephew did. I think he's waited too long to talk. Now he's going to take the fall for everybody. So have fun in prison, Keefe. Sorry. All right. Well, I'm out. I'm so glad that Cambry stopped by. Thank you very much. You're so sweet. Well, I'm at work too. I work from home, Cambry. It wasn't exciting at all. I wanted it. I bet he thought he was somebody. His lawyer didn't even show up. Bye, Cambry. Have fun. I'm ending it. Thank you. I'll see you when around. See you in chats.